Everyone. Good afternoon, everyone. I am Peggy West, the organizer for today's class. We are having a 2-hour 2022 legal update CE class by Rosenbaum PLLC. As it cools down a bit and as the air is getting a little bit crisper, we open the new season and happily want to welcome the snowbirds. So welcome back, all those that are on and attending. I also want to take a moment of silence and just remember a great American leader and patriot, former Secretary of State, General Colin Powell. So let's pause just for a minute. Thank you for that. Okay, now let's just get things going. Let's begin. I'm excited that we have approximately 170 people registered for this class today. So thank you for that. And we have many updates that Steve Brayton is going to discuss. So use your chat box. We have Matt Reedy today as moderator. He is going to read those questions in and out of the presentation. Let me start by introducing the sponsors. I'm going to start with myself. Peggy West again. I am the National Business Developer for Capital Lighting in the Pro Commercial Division. And we have been around since 1924, a commercial team for about 1.5 years now. And we are now going into holiday season. So if we can help you with any holiday solutions for money saving costs on lights, we're here to help you. But we also do landscaping, exterior lighting, lamps, and so on. With that, I'm going to go into introducing the wind beneath my wings here. Layla Scola from Vinteum Software. She's a very helpful co-organizer and director of marketing for Vinteum Software. You want to say a few words about Vinteum?
Yeah, definitely. Thank you for the lovely introduction. You make me blush here. My name's Layla. I'm the head of marketing for Vinteum. We provide websites for HOAs and condos in line with the Florida condo website law. So if you need a website, a portal to improve communication, please get in touch.
Awesome. Very good. And they have so many features. You have to at least get a presentation in to hear what you might be missing from what you don't have. Matt Reedy, I would like to introduce. He's an association specialist for Plastrage Insurance. Moderator today. Thank you again. Matt, tell us about Plastrage.
All right. Thanks, everybody. Thanks for joining us today. Matt Reedy, Plastrage Insurance, for a 102-year-old agency founded in Delray in 1919. Today, we represent a little over 1,100 condos, HOAs, and co-ops, primarily here in Southeast Florida.
Awesome. Okay. He's got a lot of clientele, so a lot of references. A lot of people like to deal with you, Matt. Next, we have Brian Van Dam from Yellowstone Landscaping. He's the business development manager. For what area, Brian?
For most of Southeast Florida.
Okay.
Thank you very much, one, for organizing and for allowing us to participate and support. Like Peggy mentioned, my name is Brian Van Dam, Business Development Manager with Yellowstone Landscape. We are a commercial landscape company. So anything you would need in the way of commercial landscape services. In addition, we can also do landscape design and install. We can do tree removal. We can do tree trimming, irrigation, maintenance, install, and repairs, as well as pest control and fertilization, flower, change outs. And we also have a hurricane plan. Would love to help support you. I know we're on the tail end of budget season. So if there's anybody that would need an RFP or a proposal for landscape management, I'm happy to come out and walk the property with you. Thanks again for having us.
Great, Brian. Awesome. Okay, next we have Kathy Dorn. She's a vice president handling association services for South State Bank. Kathy, tell us about what you do in the bank.
Thank you, Peggy. I am Kathy Dorn. I'm an association specialist with South State Bank. What do you do when you're faced with an unexpected emergency or your reserve funds may not be quite enough to cover the costs of an upcoming major improvement project? What are your options? That's where we come in as an association specialist. I work hand in hand with board members and property managers and I help them structure the best possible financing options needed to fund their projects. South State Bank, in fact, is the 6th largest association-specific bank in the United States. We have over $1 billion in association deposits, and we've been working with associations since 1986. So I appreciate the opportunity today to be part of this, and I hope everyone enjoys the webinar. Thank you, Peggy.
You're welcome, Kathy. Very nice. Okay. Let's go right into getting the class started. I want to introduce first Katie Phillips, who helped me coordinate this a little bit. Katie is the Education Director over at Rosenbaum PLLC. Katie, take it away.
Hey, so I put my video on, but you're going to hear Steve talking because I'm here with Steve and we can't both have our audio on at the same time. I am Katie Phillips, Rosenbaum PLLC. We're a full service law firm with offices in West Palm Beach and in Stewart. We handle everything in-house, including your collections, bankruptcy monitoring, your general legal matters, contract review, and document amendments. Steve is a whiz at document amendments and has actually written some articles for the Florida Condo Journal on document amendments. So with that said, Steve, I'm going to get started with the legal update.
Sure. Good afternoon, everybody. Thank you for your attendance today. We had a very active legislative session this past year, so there were a lot of changes to Florida law that we're going to talk about today. And as your questions come in, Matt will go ahead and prompt me as you guys submit questions. Try and keep your questions limited to the materials as we go over it. If you have a fact-specific question that's unique to your community, please don't be offended if I don't answer that. I can't give legal advice during the education seminar because this is for education purposes only. Just to give you a little background about myself, I've had the privilege of practicing law in the state of Florida for, I guess it's been 27 years now, and primarily in the area of community association law. Also worked for about 5 years in-house for a real estate developer on the west coast of Florida. And so I've been on both sides of the coin of dealing with owner-controlled and developer-controlled associations. So I'm going to go ahead and share our screen here now and pull up the PowerPoint. Hopefully that'll work. Let's see. And there we go. Okay. So we have the 2022 legal update. And just to let everybody know, at the conclusion of today's seminar, we will send out a PDF file of the PowerPoint presentation for your reference. So don't worry about that. As you see here from the first slide, these are all of the bills that were passed in the last legislative session, including their effective dates when they went into law. So the first change that was made in response to COVID-19 is what we refer to as a liability shield, which we'll talk about. And then there were other changes involving COVID-19, as well as changes that impacted collections, an omnibus bill that made a bunch of changes to the condominium, HOA, and co-op statutes, and some other bills that impacted board eligibility, and then to some degree, regulation of homeowners association swimming pools, and then also property insurance claims, which Matt can probably address better than I can. So we'll go ahead and talk about that a little bit as well. So I'm going to go ahead and start with the COVID-19 liability shield. And basically what the Florida legislature did there was create a protection for business organizations, which does include condominium homeowners associations and cooperatives, because all of those entities are incorporated under Florida's not-for-profit Corporation Act, and which is Chapter 617. And basically the amendment to the statutes created a new section 76838, which creates a number of hurdles for somebody who wishes to bring what the statute refers to as a COVID-19 related claim. For starters, the statute defines what a COVID related claim means, and that's a civil claim against a person or community association which arises from or is related to COVID-19. And also it's a claim for damages, injury, or death related to COVID-19. So as an association, what do we have to, how are we protected by this statute? If we look at it, the statute creates a number of hurdles that a would-be plaintiff would have to satisfy in order to get, in order to be able to move forward with a lawsuit for a COVID-19 related claim. The first thing that the plaintiff has to do is they have to submit an affidavit from a Florida licensed physician that attests to the physician's belief within a reasonable degree of medical certainty, which is a standard recognized in the law, that the plaintiff's COVID-19 related damages, injury, or death are as a result of the defendant's acts or omissions. Okay, that's number one. Number two, the court then has to determine if the community association made a good faith effort to substantially comply. Statute doesn't define what that means, but substantially comply with authoritative or controlling government issued health standards or guidance at the time the cause of action accrued. So the court's going to look at, what did the CDC have in place? What did the state, Florida State Department of Health have in place in terms of standards or guidance? And did the association make a good faith effort to substantially comply as opposed to actual compliance? Okay, so it's a lesser standard from the association's perspective in terms of complying. Okay. Now, bear in mind that if the court determines that the association did make a good faith effort with those standards or guidances, then the lawsuit is not permitted to proceed. If the court determines the association didn't make a good faith effort, then the lawsuit can proceed, but the plaintiff still has to meet a higher standard of proof, and that is they have to prove that the association was grossly negligent by clear and convincing evidence. So, we're all familiar with with negligence and the concept of negligence when somebody doesn't act with due care. Gross negligence is an even higher standard. And then the burden of proof in most civil actions is what we call the preponderance of the evidence. Now, my trial advocacy professor in law school described the preponderance of evidence as, if you're looking at the football field, I got to get past the 50-yard line to prove a case by the preponderance of evidence. When you think of a criminal case, that has to be proven by beyond a reasonable doubt. It's the equivalent of making a touchdown. Okay. Well, clear and convincing evidence is in between. I'd characterize it as you have to kick a field goal in order to prove a case by clear and convincing evidence. So it's something more than preponderance and something less than, beyond a reasonable doubt. And so basically, while it's not an absolute bar to claims, it should substantially decrease the number of claims that we see stemming from COVID-19 against associations. Okay. And in point of fact, I haven't seen any brought against our association clients that we represent. Now, Senate Bill 2006, which we refer to here as Coveted Documentation, is basically a law that prohibits businesses from requiring patrons from having to show a vaccination card in order to be, in order to gain access or entry to that business operation. And it further provides for fines of up to $5,000 for a violation of the statute. Does a business entity include a community association? The statute isn't clear. I would hazard a guess that a community association would be considered a business entity. Again, we fall under Chapter 617 as a Florida not-for-profit corporation, and therefore I would think an association would be covered by this prohibition of requiring vaccination cards to gain entry to the property. Any questions up to this point, Matt?
We've got one that's a little off topic if you want to do it.
Okay.
All right. So has the legislator made it illegal to pay a board member of a condo association, even if the documents allow for it?
If we're talking about a board member's service, then the way 718 is drafted is that a board member is not permitted to receive compensation for their service unless the documents authorize it. So if there is authority, which I rarely see, for a member of the board to be compensated for their service, then the Condominium Act does permit that, and so does the HOA Act. Typically, again, it's rare that I see that. I do have scenarios where a member of the board is providing what would be considered services above and beyond. For example, the type of services you would have an accounting service provider provide, such as bookkeeping. And in that scenario, I suggest that that person not be on the board in order to get compensated.
There's a part two to that. Is there a difference between payment and honorarium?
I think if you're receiving something of value, it's compensation. Again, I think if the documents permit something like that, it's fine. If they don't, then I wouldn't recommend.
All right, that's all we got for now.
Good. All right, so moving on, some changes that were made to the corporation statutes that may impact community associations was SB 602. Whoops. And basically, this was a little cleanup work by the legislature, and that was to say that the quorum requirements set forth in Chapter 617 to amend the governing documents do not apply to condominiums, co-ops, or homeowners associations or mobile homes. Something we already probably thought was the case has just been made official. Not a big deal there. So now let's talk about something that's been a bit controversial, and that has to do with Senate Bill 56, which added this new collection letter to the already existing statutory letters for condominium and homeowners associations and cooperatives. So under the law prior to this change, condominiums and homeowners associations had to send out two statutory letters. The first letter being a notice to the owner that the association intended to record a lien against the owner's unit or property if they didn't pay their account, notice of intent to lien. And then if the owner didn't pay in accordance with that letter, the second statutory letter was a notice of intent to file foreclosure. The legislature has now added a third letter, and this letter has to come before the two I just described. And basically, it's what I refer to as the free letter, meaning the association cannot charge attorney's fees for sending this letter to the owner. All right, so let's get into this a little bit. So basically, the legislature at 718-121, 719-108, and 720-3085 created this new notice of late assessment. The notice of late assessments must be sent by first-class mail to the last address reflected in the association's records. Now, it's still the owner's burden to make sure that the association has the correct address on file. And for those folks who go back and forth between out-of-state and in-state residents, it's important for the owner to notify where the association should be directing mail. There is a rebuttable presumption per the statute that if the association mailed a notice in accordance with the statute, that it was actually received by the owner. However, there needs to be an affidavit by the board member, manager, or whoever the agent is of the association mailing the notice to create this rebuttable presumption that it was actually mailed. Now, practically speaking, if you're a large community and you're sending out, a fair number of letters at a time, do I have to have a separate affidavit for each notice I send? I think you could create a schedule that you can attach to the affidavit of all the properties that were sent the notice on a given day and on a given date, and that would be sufficient. Now, the statute itself actually includes a form notice of late assessment that associations have to substantially comply with. When you look at the statutory form, it leaves some questions unanswered. It talks about maintenance, doesn't say assessments, but I think it's fair to say that we're talking about maintenance assessments. It doesn't make reference to special assessments. It does indicate that the association has to disclose the interest rate that the assessments are accruing, and the per diem as well. So that's also important. Okay. The statutes also provide that if an association is providing a method of invoicing assessments or issuing statements of account, that before it changes that method, it has to provide, get this, you have to provide written notice of the change. And the written notice must be delivered at least 30 days before the association sends the invoice for assessment or the statement of account by the new delivery method. Okay, and I think, let's see, the notice has to be sent first class mail, again, to the last address on record. And the unit owner must affirmatively acknowledge his or her understanding that the association will change its method of delivery. Okay, so what if they don't do that? If the unit owner doesn't make an affirmative acknowledgement, it sounds to me like you can't change your method of delivery. So not sure what the idea was behind this method. I think the concern is that owners get notice of the assessments that are due and owing. However, usually with the exception of a special assessment, the governing documents, state the due date, and the association has to send out a budget to the owners, letting them know what the assessment is. So, when I look at this, I see this as a bit overkill and creates an administrative nightmare for associations and managers alike. Does anybody have any questions on that notice of late assessment change? All right, moving along. The affirmative acknowledgements that are required by this statute are considered an official record, but are exempt from inspection. And the other thing that was changed here for condominiums and cooperatives is that the statutory letters that I had talked about initially, the notice of intent to record a lien and the notice of intent to foreclose, those used to be 30-day notices. They've now been changed to 45-day notices, which is similar to the HOA Act, which already provided for a 45-day notice.
Steve, really quick, we did get a
Sure.
question typed in. Can an assessment notice be sent by email, or is it only first class mail?
So the notice of late assessment can be sent by electronic mail if the owner has consented to receive notices by electronic mail. So we need to have a written consent on file before you can send it that way. Otherwise, it has to go first class mail.
All right. Do you have a section coming up on fiduciary duty of the board, or you want to knock this one out?
No, I can take that. That's not something we specifically cover in this update. Go ahead. Sure.
HOA boards have a fiduciary duty to protect association from lawsuit. But what is the standard for recognizing a legitimate threat versus an empty threat, since a serious threat may require notifying insurance and counsel in convening executive session?
Yeah, so it's hard, and Matt, you can certainly jump in on this one too. It's hard to distinguish between what's considered, quote, an empty threat versus a legitimate threat. If somebody, asserts in writing that a claim against the association, whether it's personal injury or breach of fiduciary duty, the association's policies of insurance require the association to provide the appropriate carrier with timely notice of the claim. And so if you don't report the claim, it's at the association's risk, because if that claim then does come to fruition, you're giving the carrier the ability to deny the claim for failure to give proper notice. Now, does the carrier have to be prejudiced by the delay? I think they do, but that's inviting litigation between you and your carrier. So, Matt, what are your thoughts on that?
I mean, I think you hit the nail on the head. Is the clear line is once you have something in writing from somebody that it typically needs to be turned in. Now, let's say, use a real example. A few weeks ago, I had a community where a woman claimed she had an injury. And when the board went back and the manager went back and reviewed the video footage they had of the particular event, nothing that this woman said was actually accurate. Nothing fell on her. She was never on the ground. but she'd been going around for a week or so telling everybody in the community that she had been injured and it was the association's fault. And then she got a chance to review the footage and kind of backtracked, and we haven't heard from her since. So when you get any potential allegations of somebody getting hurt, especially with the litigious nature that we have here in South Florida, where most of our companies, their largest loss ratios in the country are in South Florida because of how prone we are to sue down here. So I always lean on the more conservative approach, because you can absolutely, bite you in the butt if you don't turn in a claim and they decline it later because you failed to turn it in. But, you also don't want to just throw everything that happens where, somebody tripped on an acorn, so you turn it into the company, even when the person's saying that they weren't injured and they don't want to file a claim. There's clear ones that you don't turn in, but it's more of a case-by-case basis. It's certainly worth talking to your agent. For me, I don't charge an hourly rate to ask me questions compared to the attorney. So you can kind of start, well, nature of the business, but you can at least start there. And then, if you get, anytime you have a third party send a letter in from their attorney, that's another clear cut.
Oh, yeah.
Get the claim started. And once they've contacted legal advice. So there's it's more of a case by case, and start the conversation, and every claim is a little different. So
Absolutely. When we get those letters demanding disclosure of insurance pursuant to, 627, that's a pretty good indicator. You need to send
cut
it
and
to
dry.
the carrier. Yeah,
Cut and dry.
absolutely.
Not to throw you under the bus there, Steve.
Yeah, no, it's fine. I get it. And also having the video footage in that scenario is certainly fortuitous. Not every, that may not be available. So again, I agree with Matt. You have to take it on a case by case basis, and, to consult your professionals, and then, err on the side of caution. So let's see, talking about insurance, one of the changes that occurred with 627 was to prohibit a condominium unit owner's insurance policy from including a subrogation provision in the policy unless the condominium association's policy allows the association's insurer to subrogate against the owner. So, the whole topic of condominium insurance could be a separate seminar in and of itself. But just to, real quick, 718.111 describes the types of insurance a condominium association is supposed to carry, the type of insurance, and what what the unit owner is responsible for. Whether an owner actually has insurance is a whole nother discussion. There is no statutory mandate anymore for unit owners to have insurance on their condominium unit. But basically, subrogation is a scenario where the carrier determines that somebody else, whether it's the condominium or the unit owner, was at fault, at least in part, for the casualty event. And so they want to go back against the other party to reimburse for the damages they paid out to their insured. So basically, this is trying to put the association on the owner and the owner on even footing. If the condo policy excludes subrogation against owners, then owners aren't going to be able to go against the condominium, because at the end of the day, whose pocket is the money coming out of? Ultimately, it's the unit owner's pocket who's paying for the insurance, and the more claims we have, the greater the premiums go up. So, Matt, is there anything I missed on that you want to?
No, it's pretty good. I will add that
It's pretty good.
from the industry standpoint for insurance, this was seen as a big win, because the number of subrogations claims we've seen for the last several years have just been going up and up and up. And it was a one-way road where the unit owner's policy could subrogate against the association, but we couldn't go back against the unit owner's policy either. Now, a lot of the policies did have that language where the association couldn't go after the owner's policy, but again, they were coming back after us. So the statute, when it was passed, it was not, correct me if I'm wrong, Steve, but I don't believe it was retroactive. So once it was passed, it's effective on all policies going forward. So there's some speculation we may see a runoff and a focus on getting as much money out of the association's policies as they can before that goes away for the personal lines companies. But that's
Yeah, no,
this was a really big win.
Yeah, I agree with that. And there's one carrier in particular that has a very active subrogation group. And that'll probably shut down that whole department, once
It'll be
once we
interesting.
filter
to see.
through the next insurance policy, period here.
Right.
But yeah, no, I agree. This was definitely a win for the association's carriers and policies, and hopefully we'll see some cost savings down the road. All right, so moving on to some of the other changes that occurred with the omnibus bill, and that is some changes were made to 718 about mandating bids being kept as official records for at least 1 year. And so one of the questions I get is, do I have to keep bids for work we didn't accept? And the answer is yes. Whether you actually accepted the bid or not, if you receive bids for work to be performed, you need to keep all those bids for 1 year. There's no dollar threshold on the bid amounts. Another change we had to 718 had to do with allowing renters to inspect the declaration of condominium. So initially it was limited to the rules and regulations. Now it's the declaration of condominium as well. Yeah, and that's a document that's in the public record. As a reminder, you're entitled both as an HOA, condo, HOA and co-op. You're allowed to adopt rules governing the frequency, time, location, notice and manner inspection of official records. And I strongly recommend to all our association clients that you not wait until you have an owner who is hitting you with request after request after request to put these rules in place, but rather have them in place upfront in order to discourage the person who's going to sit at their computer and shoot email after email out asking for one record after the next, but rather make them think about what they want, actually submit a comprehensive request, and limit the number of requests that you can have in a given month from one owner to inspect records, so that your manager or your board isn't inundated and consumed with having to deal with this type of repetitive or successive requests from one owner, which is what I typically see. There was another change, miscellaneous change to the Condominium Act, which allows condominium associations to extinguish discriminatory provisions in their this typically affects old condominium declarations without needing a membership vote to terminate that provision. It can be done by a majority vote of board members and then recorded in the public record. Another one this is probably a little bit more near and dear to many. We had a lot of controversy over the last several years with changes to 718 concerning board members and term limits. And so finally, we got clarity from the legislature that passed amendments that prevented a director from serving more than 8 consecutive years without getting a higher threshold vote when it is only effective from July 1st, 2018 forward. So essentially, this doesn't become an issue for somebody unless they've been serving 8 consecutive years beginning in July through 2016. And then if you end up in that situation, it doesn't mean you can't run. It means that you need to get 2/3 vote of the members participating in the election voting, or if there's not enough directors, or if there's less than or equal number of candidates to the seats that are up for election, you can serve another term. Transfer fees, the amount that condominium associations can charge for an application in connection with a sale or lease or other type of transfer was increased from 100 to 150. And it's now future increases are now tied to CPI increases for inflation. But bear in mind, before you can charge a transfer fee, there are 2 requirements. Number 1, that you have a right to approve a transfer, and 2, that your documents, your declaration of condominium, bylaws, or articles of incorporation actually authorize you to charge the fee. So oftentimes I see the right of approval without the authority to charge a fee, or I don't even see the right of approval in the documents, and we have associations charging the transfer fee. So be very careful on that, because that is considered a major violation by the Division of Condominiums. Let's see, the 718 was also amended with respect to posting of notices for annual meetings. Annual meetings now must include an agenda and has to be transmitted, excuse me, at least 14 days before the meeting. Not sure this is, surprising. Most bylaws require notices of members' meetings to be transmitted at least 14 days before the meeting. But the other significant change here was with respect to the second notice of elections. And it says that the second notice cannot be sent out more than 34 days and not less than 14 days. So that was just a minor clarification. For those familiar with the condo election process, we know that candidates have to give their notice of intent 40 days before the annual election, and they have to provide that candidate information sheet 35 days before. So that second notice can't go out until 34 days before, because we have to include all of the timely candidate information sheets that have been submitted by candidates.
All right, Steve, we got a pair of questions going back to the transfer fees. If you're ready.
Go for it.
We are currently charging $100 for our transfer fee. Our documents allow us, if we want to increase to $150, does that have to be approved at a board meeting?
If the documents don't contain a cap on what you can charge, but do authorize a transfer fee, I don't see any, does the board have to do it? The statute gives you the authority to do it. It doesn't hurt to do it at a board meeting. This way, everybody's on notice that this is going to be changed moving forward. And then also make sure management, if you have management, updates your paperwork to reflect the new amount. So I think it's good practice to have that meeting, have that vote and document it in the minutes.
Perfect. Yeah, it's not going to hurt you to do it.
Yeah.
Transfer fees in an HOA must be in declaration or in articles of incorporation.
So the authority to charge a transfer fee would need to be in the declaration of the homeowners association or the bylaws. Typically, I would expect to see it in the declaration. I don't think that's something that the association can do by rulemaking authority. So if a homeowners association has the right to approve a sale or lease, but there's no authority to charge a fee associated with the application process, if there is one provided for in the documents, then I think you have a problem. And you would need to do an amendment. But if there is a fee, if there's an authorization for the board to charge a fee, then the board would have to establish what that amount is. And I would suggest it would need to be a reasonable amount designed to cover the cost of the application process and administrative costs, not be a profit center. So, if you're charging somewhere in the neighborhood of $250 to $350 as an HOA to run background checks, and because your management company is charging you, then there needs to be a rational relation from between the fee and what it's costing the association to manage the process. Now, another change that's significant to 718 and also 719 and 720, which I cover later in the slides, but I'm going to address it as a single here. And that is unit owners, when dealing with recall petitions, can either now file an arbitration or a litigation and with respect to challenging a board's recall decision. So it used to be that the Division of Condominiums had exclusive jurisdiction to deal with recalls and election challenges, both under 718 and 720. So now you can go either to the Division of Condominiums or state court. There's also was a recent decision by the appellate courts that say that a party cannot be compelled to mandatory binding arbitration, which these recall and election disputes are when you go to the division. So something to keep in mind. Electric vehicle charging stations, the statutes, 718 was amended to incorporate natural gas fueled vehicles. So the way the statute was worded is it provided that under certain conditions, the association had to permit an owner to install an electric vehicle charging station in their limited common element or exclusively designated parking spot. Now that also includes a natural gas fueling station. And this is an issue that I see coming up more and more, where associations are trying to deal with how to manage these requests and what they should and shouldn't do. Bear in mind that the association can't prohibit somebody from installing one of these types of stations, but there are a number of conditions that the owner has to meet in order to do so, including being responsible for repairing any damage they may cause to the common elements to run electric or a line of gas line to the fuel station. So if you get presented with one of these requests, you should definitely seek association counsel's guidance on how to manage those requests. And then you also, as a condominium association, may want to think about proactively installing common element electric charging stations, which may make it more, may make these individual requests less likely, if that's a concern. Let's see. 718.121 was amended when we talk about the notice of intent to lien. It now says that it's deemed delivered when mailed, which is basically the mailbox rule. There was also another significant change with regard to arbitration by condominium associations. And now condominium associations can elect to do what homeowners associations have been able to do for years now. And that is, prior to filing a legal action, sending out a pre-suit mediation notice, meaning giving the owner an opportunity to mediate the dispute prior to filing a lawsuit. And then rather than filing with the Division of Arbitration, a condominium association can elect to file that lawsuit in state court. This is something that I think is a significant improvement for our condominium association clients, because when you go to the division with an arbitration petition, if the arbitrator issues an order, the owner still has the right to seek what's called a trial de novo in state court, which is basically a review of the arbitrator's order. Or if the owner doesn't comply with an order entered in favor of the association still has to file a petition to enforce that order in state court, because an arbitrator's order cannot be enforced with the contempt powers that a state judge has, which includes fines and incarceration. So if you go the arbitration route, it's a two-step process. Now you have the ability to avoid that first step, do the pre-suit mediation notice, and then go straight to state court. Now, probably one of the bigger changes that occurred in the legislative process last year had to do with the emergency power statutes for condominiums, cooperatives, and HOAs. There was a lot of debate during COVID-19 about what associations could and could not do during a state of emergency. The legislature tried to address that. I think they did some good things and then perhaps created some confusion. And then also they did some other things that may not be too palatable for associations. So we'll talk about that. Number one, they expanded the definition of emergency to provide for a scenario such as the one we were faced with COVID-19, and not just limit emergency powers to natural disasters such as hurricanes or other weather events. So that was certainly a positive. Number two, they granted the authority of boards, committees, and members to have meetings in whole or in part by telephone, real-time video conferencing, or similar electronic or video communication mechanisms, giving notice in a manner that's practicable. But again, only during a state of emergency. So where I think the legislature missed the mark here is allowing associations to conduct board meetings, committee meetings, elections, and members meetings in non-states of emergency by these mechanisms. Now, boards and committees have always been able to meet by teleconference or video conference, so long as the members can hear the board members. But when we're not in a state of an emergency, you can no longer conduct these meetings exclusively by those means. So if your board is still doing Zoom meetings and not providing members an opportunity to attend a meeting in person, you're probably in violation of the statutes right now. So, I think that should have been an option, that non-emergency times that the associations could conduct these meetings without members having to be physically present. The other thing that the emergency statutes were amended to provide for is that associations can now implement a disaster or emergency plan before one occurs, during the event, or following the event for which the state of emergency is declared. And this can include, but not limited to, shutting down portions of, for example, in condominiums, elevators, electricity, water, sewer, or security systems or air conditioners. I would strongly suggest before a board does something like that, that they consult with their, engineering professionals to make sure it's appropriate to do that under the circumstances, and that it be for life safety reasons. Now, one of the things that the legislature implemented that may or may not be too palatable, and I'll just read it from the statute. It says, notwithstanding the powers that have been granted under other paragraphs of the statutes, during a state of emergency declared by executive order or by proclamation of the governor, an association may not prohibit unit owners, tenants, guests, agents, or invitees from accessing the unit and the common elements and limited common elements, or in the case of an HOA, it would be the association property or community facilities, for purposes of ingress and egress when access is necessary in connection with the sale, lease, or other transfer of title of the unit, or the habitability of the unit, or for the health and safety of such person, unless there's been a governmental order or determination by a public health directive, such as from the Centers of Disease Control and Prevention, prohibiting such access. So basically, I know we had scenarios where a lot of associations had implemented rules and regulations during the state of emergency for COVID, preventing guests from coming to the property, preventing sales agents from showing property for lease or sale. And this statutory amendment prohibits that unless there's a specific order that's been issued that says that's okay. So, just be mindful of that. Questions that pertain to the states of, the changes in the emergency statutes?
All right, we got a question for you, Steve.
Sure.
How do we conduct board of directors meetings when the board each lives at a distance and there is no board member that lives full-time at that condo itself? How do you recommend handling those meetings?
Yeah, so it gets difficult. Again, members of the board can hold meetings and all of the members of the board can be remote, but somebody needs to be, at a physical location so that members of the association who attend that meeting can hear the meeting take place and they have a right to speak on the agenda items for the meeting. So at least one person is going to need to be at a location where there's some type of equipment set up that facilitates, the board meeting by, electronic conferencing, whether it's phone or video. So in the case of a community that's managed by a community manager, the manager is probably going to be the one that has to facilitate that. If you're a self-managed community, then you're going to need at least one board member who's present at the property in order to conduct those meetings. Now, if you're an HOA and you're conducting an exclusively, Zoom meeting, it's going to require that owner to bring a lawsuit to compel you to hold an in-person option. If you're a condominium or a co-op, it's a lot easier for the owner to file a complaint with the Department of Business and Professional Regulation, and you're going to get cited for violating the statute. So, that's why I say I think the legislature missed the mark and not allowing board meetings and committee meetings to take place exclusively by video conferencing and teleconferencing. So
now, as a quick follow-up to that, you said it would have to be a board member who's on the location to help set up a conference line. Could it be anybody from the community? And
Well, I guess, if you can get, if you can have a committee, you can have some volunteer who's there that's going to facilitate, the equipment that's going to allow members to hear what the board is saying. So I guess it doesn't necessarily have to be a director if you can rely on somebody else to do that for you.
Perfect. Here we go. How can you hold a board meeting? How can you hold a board meeting at an HOA community when bylaws require 3 to 5 members? Only have 2 board members who knowingly don't want, or to at least appoint a 3rd board member. Trying to make
That sounds like a fairly specific question. So basically, the general answer to that is, in order to conduct a board meeting, you have to have a quorum of the board present, and either physically present or attending via one of these teleconferencing or video conferencing services. If certain members of the board are frustrating the board's ability to obtain a quorum in order to conduct business, then you have a problem, and I think you need to consult association legal counsel to figure out what's the best solution to address that problem.
Okay. You got one. This one doesn't wait about 25 minutes. Should be an easy one to knock out. Do you see legislative law will move to require a code of conduct for board members?
It would be nice. I don't think the legislature is going to ever incorporate a specific set of rules that we would consider to be a code of conduct. I think that's something that each association has the authority, every association has the authority to implement. And I know that the Community Association Institute has a set of model rules for a code of conduct for board members. And, a lot of associations do implement a code of conduct as well as an ethics policy, which incorporates a lot of what the statutes prohibit, directors from doing, which includes taking kickbacks or soliciting, compensation in exchange for awarding contracts or any of these other things that would be considered a no-no. Should an association have a code of conduct for their board? I think it's a good idea. This way, the board can say, hey, look, we've taken the appropriate steps necessary to ensure that we're, discharging our fiduciary duty. But then bear in mind that code of conduct can come back to hurt you in a lawsuit if you're not following it. So it can be a double-edged sword as well. But I don't see the legislature implementing that type of thing. I think they've regulated board members' conduct to such a degree that there's enough out there that if board members are doing things wrong, there's remedies for the owners.
Right, I'd agree with that.
Yeah.
Currently, Palm Beach County has lifted all COVID-19 restrictions. Thus, we can no longer hold only virtual board meetings, correct?
That's correct.
Okay.
I still think you can provide members the option to attend these meetings by, Zoom or other video conferencing platforms, but I don't think you can do a meeting exclusively that way. You have to give the owners the option to attend in person if they want. Now, if you want to require that, can you even require a facial mask to be worn? I think you can just say it's recommended. And that's about all you can do at this point. And that's why I like having the video conferencing option, because if people don't want to come in person, they don't have to, but they can still partake in the meeting. And I think that's a good thing.
Okay, 2 more here.
All right.
What is the statute of limitations for claims against an association relating to infringement of documents by removal of a listed tennis court or shuffleboard to pickleball courts? That's a very specific question. Doc say 8, but there are only 7. Can the association still be sued?
Yeah, so the general rule of thumb on a statute of limitations that for a cause of action for something that's in violation of the governing documents of a community association is 5 years. If there's a specific scenario involved, then I would strongly recommend you discuss that with association legal counsel who'll be familiar with the specific facts. but breach of contract in Florida is a 5-year statute of limitations from the date that the breach occurred. And there may be exceptions to that. So moving on, I got to move on to a couple other things here. Some other statutory changes that occurred for condominiums and HOAs is there was a change to the defining statutes that provide notice of approved fine or suspension has to be provided to the unit owner, and if applicable to the tenant, licensee, or invitee of the owner. And the statute was changed to say it's 5 days. The fine is due and payable within 5 days from when the letter is provided to the owner notifying them of the fine. So, you know, the important takeaways here are notice to the owner, a fine has been imposed or a suspension has been imposed, and then, you know, making sure the letter specifies when the fine is due or when the suspension is applicable, and it should be sometime after the date of the letter provided to the owner, so that they have a reasonable opportunity to be aware of that. They shouldn't find the first time they find out that that their fob has been shut off to the common facilities shouldn't be the first time they go try and use the facilities. You know, there were some other changes to this Condominium Act that had to do with developers that probably doesn't apply to most of our listeners, so I'm just going to skip over that. The cooperative changes were similar to what we dealt with for condominiums. One change that was important for co-ops had to do with the definition of unit. The legislature finally made clear that a unit is an interest in real property because as many of our cooperative owners know, the co-op, your ownership interest was in a share of the corporation, coupled with what they called a minument of title, which was the leasehold interest under your lease with the co-op. And so now they've clarified this and said a unit, the unit is a real property interest, and this has ramifications under homestead law and for other reasons as well. So let's see. Similar changes with regard to dispute resolution apply to co-ops now, and as well as all the changes to the emergency statutes that we talked about for condos applies to co-ops and HOAs. Let's see. So some specific changes to HOAs that I haven't talked about yet had to do with the change in the definition of governing document. A few years back, the legislature changed the definition of governing document to include rules and regulations. This had a number of unintended consequences, including requiring HOAs to record changes to their rules and regulations in the same manner that amendments to their other governing documents were recorded. So that is now gone. There also was a change in terms of where amendments to the governing documents have to be mailed to, which I'll talk about in a minute. 720-303 having to do with board meeting notices now allows the association to adopt a rule that allows the board meeting notices to be posted on the association's website or an application that can be downloaded from a mobile device. If the association posts notice in such a manner, they must also email a notice to the email addresses in the association's official records. So again, an attempt by the legislature to modernize the notice process for meetings. I don't think they're quite there yet, but we're moving in the right direction. Another significant change for HOAs is that election records now have to be kept for 1 year from the date of the election. The statute didn't specifically address that, so it wasn't clear whether these documents had to be kept for 7 years or only for 60 days, because election challenges can only be brought within 60 days after the election results are announced. So that mystery has been put to bed. It's 1 year after the election, including ballots, sign-in sheets, voting proxies, and anything else related to the election, including electronic records. So that's important. If you're using a electronic voting vendor, you need to make sure that there's a record retention process in place with the vendor, whereby they either provide those records to the association or they keep them for you for the statutory period. Another addition here is that for gated communities, the statute was amended to exempt records that are gathered in connection with guest visits or community, in connection with guests visiting the community. So those are exempt from records inspection. 72303 was substantially revised in favor of developers when it comes to new communities and what the developer's obligations are vis-a-vis reserve funding. This was quite a complicated revision to the statute. So I'm not going to dig into this because most of our communities it won't apply to. But if you're a community that's recently gone through turnover or is about to go through turnover, this could impact your community. And so I would certainly seek out legal counsel's advice on this issue. Okay.
It'll probably be changing by next year.
Yeah, no, basically the long and the short of it is it now says that a developer has no obligation to fund reserves. They don't have the obligation to follow the statutory process that was in place to waive reserves. And what it's going to probably do is encourage developers not to fund reserves during the developer control period. And that's going to leave associations with having to do quite a bit of makeup in terms of reserve funding after turnover. Now that's only as to HOAs, not to condos. Same thing that we talked about before with regard to recall and election challenges applies to HOAs and just harmonizes the jurisdictional period of time to hear a recall petition, which is 60 days. The courts cannot entertain recall petitions within 60 days before an election, just like the division couldn't entertain a recall petition within 60 days prior to an election. Also, election recalls typically, cannot be implemented within 60 days after an election. Okay. Now, when we're talking about amendments that have been done to HOA documents, this was a change I talked about before. It used to be that you had to check the website for the property appraiser in the county in which your association was located to verify not the property, but the mailing address on file with the property appraiser. And the amendment had to be sent to that address, which could be different from the property address. It could be the owner's out-of-state address, it could be another address in the state of Florida. So that was a significant administrative burden on associations, especially larger ones. So that's been eliminated. And we're now back to mailing amendments to the parcel owner's address as reflected in the association's official records. So whatever that last address on file, that's where the amendment needs to be sent to. There were some significant changes in terms of amendments that prohibit rental restrictions in homeowners associations. And these changes are at 72306 1H. And essentially it talks, it's somewhat similar to what condominium associations have been dealing with, where the owner has to vote in favor of the amendment in order for the amendment to apply to the owner with certain exceptions. And those exceptions are, and these are amendments after July 1st, 2021. So let me preface that. If the amendment is adopted after July 1st, 2021, you need to deal with this new statutory scheme. The exceptions are for amendments which restrict rentals to less than 6 months or more than 3 rentals in a calendar year. If the amendment states in the amendment that it doesn't affect, if for associations with 15 or fewer parcels, this statute doesn't impact you, but also if you do the amendment to say it doesn't impact existing owners and only applies to future owners after the amendment is recorded, then you're also in good shape there. Now, one of the things that the statute says is that for purposes of a change in ownership, a change in ownership does not occur, meaning we're not going to apply a new amendment restricting rentals to someone where the change in ownership is an affiliated entity or a beneficial owner. So for example, if the property was owned in a trust and the property was transferred to the beneficial, beneficiary under the trust, that's not going to be considered a change in ownership. Or if it was owned by a business entity, then any person that was associated with the business entity is going to be considered affiliated with that ownership. So, again, when you get into these issues, you're going to need to consult association counsel because it gets very complicated. Similar changes with regard to dispute resolution and extinguishing discriminatory provisions also apply to HOAs. We had similar changes to the Emergency Powers Act for HOAs. And again, just as a reminder, association it prevents the association from prohibiting parcel owners, tenants, and guests, agents, or invitees from the use of the common areas and facilities for the purpose of ingress and egress or in connection with the sale or lease of a unit. So there's going to have to be some type of emergency order in place that prohibits that in order for an association to do that during a state of emergency. Next topic we get into has to do with board eligibility and budgets. I'm not sure if we've got any questions at this point, Matt. Let me know.
You've been pretty quiet.
Okay. This next bill, which was SB 1966, prohibits, they made some changes in terms of board eligibility. It limited actually the type of obligation that prevents somebody from being eligible to serve on the board. So now in condo land, you have to be delinquent on any assessment, whereas before it said any monetary obligation, which could include, fines. So now to be ineligible to run for the board and for a condominium, you have to be delinquent in the payment of assessments on the last day that person would be eligible to run for the board, which is that deadline for the notice of intent.
Does that include late fees on those assessments?
Well, it doesn't say that. It just says if the director was delinquent on any assessments. So if there's a late fee outstanding, arguably that's not an assessment. And that would get into how the payment got applied in accordance with the statute. So again, if you're going to disqualify somebody from running from the board based on a failure to make a payment to the association, I would have association legal counsel review the ledger either with the board or management to make sure you're properly disqualifying somebody, because you can anticipate an election challenge from that disqualified candidate if you've done so wrongfully, and then you're going to be doing the election over. So 718-112 was amended to mandate the board to adopt a budget at least 14 days prior to the start of the association's fiscal year, and the failure to do so now is considered a minor violation of the Condominium Act. I think before the statute provided that if the board didn't adopt a budget, the prior year's budget rolled over. That's not going to work anymore. You need to adopt a budget every year prior to the fiscal year. And that has to happen at least 14 days prior. Now, most condominium association bylaws require the time frame and sometimes specify what month the budget meeting, the annual budget meeting, has to take place. So it's important to be aware of that as well. Similar for cooperatives, having to adopt a budget 14 days prior to the fiscal year. And don't always assume your fiscal year is the calendar year. That's important. You verify that. It should be in the articles of incorporation or bylaws as to what the fiscal year is for the association. And then we're going to get into here another change, which was HB 649, which basically now allows an association to challenge on behalf of its owners a change to the ad valorem tax affecting real estate in the association, within the association. So that, there may be a change that impacted more than one owner or all of the owners, in which case the association would have standing to bring that challenge on behalf of all of the owners.
Steve, we've got one going back to budgets here for you. In an HOA community, does the board president alone do the budget, or should all board members be involved? How do you know if there's more than one person involved in doing the budget?
Yeah, so what the condominium and HOA statutes discuss is, the association has the authority, or the board has the authority to create a budget committee. Doesn't have to. And what authority that budget committee has is within the discretion of the board. On the other side of it, there is no rule of thumb in terms of who prepares the budget for the board's consideration. I would think that duty would fall to the treasurer. I would think the treasurer would be the officer that would make the most sense to at least start the budget preparation process. But bear in mind, the budget cannot be unilaterally implemented by any one director. It has to be approved by a majority of the board. If it's a condominium association, then the association has to prepare a budget that includes the full funding of reserves specified in the Condominium Act. And this gets a little complicated, and making sure that you are actually fully funding reserves. It requires the associations to conduct reserve studies on what I consider a regular basis, every 3 years, for example. One thing I can tell you, which is kind of off topic, and we'll be seeing this time next year, I'll be talking about all the legislative changes that were implemented to deal with the Surfside tragedy. And, we're certainly expecting some changes in terms of what condominium associations can do in terms of waiving reserves, whether the voting threshold is going to change. Right now, it's a majority of the membership. We could see that number go up to 2/3 or 75%. I would expect them to put back in the statute a mandatory reserve study requirement that was taken out of the statute. It used to be mandated that reserve studies be done every 3 years. And they may also implement certain minimum qualifications for companies who perform reserve studies. For example, you may have to be a Florida licensed engineer in order to do a reserve study, or perhaps a certified public accountant, as opposed to a company that doesn't have any specific licensure that holds themselves out as reserve study specialists. So all of this is going to be heavily debated in the next legislative session. And we're definitely going to see some changes. We'll see some changes to the Florida Building Code. Get ready is all I can tell you.
Yeah, there's gonna be some wholesale changes there.
Yeah.
I've got another one that goes back to rentals that we've been hanging on to for a question break. If a
Okay.
condo board wants to restrict rentals, what limitations can they put into the rules without having to have an amendment to the documents?
Yeah, I hate to answer the question. It depends, but it really depends on the terms of the specific declaration of condominium. Here's what I will tell you. The general rule of thumb is the board cannot adopt a rule that infringes upon an express or an implied, okay, and that's the key word there, an express or implied right set forth in the declaration. So if your declaration of condominium doesn't already contain a restriction that says owners may only lease their units X times per calendar year, then the board's is not going to be able to implement such a limitation by rule. Okay, you're going to have to do an amendment. And I know this becomes a real problem where you have condo decks that require 75% approval in order to get an amendment passed, because that's almost next to impossible. So again, if it's, when it's specific to your declaration, have legal counsel give you an opinion as what's the best, what's the best path forward.
We've got one that just got typed in for
Sure.
foreclosures. You got foreclosures coming up, or hit it now?
No, go ahead. We can hit it. I already covered the assessment notice.
Has any changes been done to the ability to foreclose a unit in a condominium where the bank prevents the unit foreclosure and holds the foreclosing on the unit, and then only has to pay 1% or 12 months, whichever is less? We're the only state that allows that.
Okay, so I think I understand the question. I'm going to rephrase it a little bit. It sounds like the question goes to the scenario where the owner is delinquent in paying assessments and they've already defaulted on their mortgage, and the mortgage lender has already filed a foreclosure action, but they're dragging their feet in terms of moving that mortgage foreclosure forward. And so the association doesn't want to spend the money on their own foreclosure because they know the bank is going to substantially wipe out the outstanding indebtedness. The answer to that is there are things you can do in the context of mortgage foreclosure to push things forward and try and get the court to accelerate that process. Unfortunately, the court system was dramatically slowed down in 2020. And then there were moratoriums that were put in place on mortgage foreclosures that may now be first starting to get back on track. So the good news for associations is that based on the real estate market we're in, most properties have equity, whereas back during the real estate crisis, there wasn't. And we're seeing a lot more surplus funds resulting from, mortgage foreclosure sales. And I'm also seeing third-party buyers more frequently in association foreclosure sales. So the hesitation to move forward with a lien foreclosure by the association where there's a mortgage foreclosure that's just sitting dead in the water. Again, talk to your counsel, see whether it makes sense to move that case forward or prosecute your own case as quickly as possible so that you can trigger a sale and possibly a third-party buyer that's going to pay you off. So.
Perfect.
So I'm sorry, I'm losing my voice a little bit here. All right. Well, there's only a couple more items here on the presentation. One of the bills that was passed had to do with HOA pools where there was 32 lots or less. And basically, the change in the law was such that it doesn't require that there be restrooms available if your homeowners association is 32 lots or less, unless, you're operating in a way that you would be considered a public lodging establishment, which is highly unlikely in terms of, all of the safety requirements and chemicals. None of that's changed. You're still regulated by the Department of Health, and you still can be shut down if your chlorine levels aren't where they need to be. Property insurance claims. Let's see what we have behind SB 76 here. So this created certain it prohibited certain acts of contractors and public adjusters related to property insurance claims. It reduced the time frame in which a property insurance claim may be reopened. It created notice to the insurer with regard to the amount claimed for damages and attorney's fees as condition precedent filing a lawsuit. So the notice has to be given to the insurer first before a lawsuit can be filed, and that you intend to assert a claim for damages and attorney's fees. Basically, these were changes that favors insurance companies. No surprise given the size of their lobby. And it also limits the recovery of attorney's fees based on the percentage of the dispute of the amount of insurance proceeds in dispute in the lawsuit. So again, all very favorable to insurance carriers. Matt, not sure if you have any add-ons to that, but not favorable to insurance.
Yeah, I mean, it's been a brutal couple of years. I could and I've done an hour-long webinar on just what's happening in the property market. I guess what I'd touch on quickly is some of this is action to curb the amount of litigated insurance claims brought against companies. Where in Florida, I think it was 3 or 4 times the amount of claims where the first notice of loss to the insurance company was the legal letter from the attorney and the public adjusters suing the insurance company before they'd ever had a chance to handle a claim through the traditional method and before they'd ever had a chance to handle a claim the right way. One of the best articles that's been written this year, at least for the Florida property market, was by the CEO of Citizens. It was written in April. And the Florida Office of Insurance Regulations did a study of 750 companies that write property insurance through the United States. And in that study, Florida accounted for 8% of the total property claims. And you know what, I can live with that. We've got a high population and we've got a pretty high catastrophic exposure for claims. And so a lot of that probably had to do with the tail runoff of even Irma claims that are still open or were filed, because before this, you could file a hurricane claim up to 3 years after the date of the storm. But in this study, they found, okay, 8% of total property claims in the country came from Florida, but 76% of litigated property claims came from Florida. And so that was just absolutely astonishing to see. And we knew it was pretty high, but I don't think anybody really guessed it was that high unless you were on the inside of the industry there. So trying to cut down on those claims where the first notice of loss is just the lawsuit from the insured on behalf of the public adjuster. And the first bullet point on this is there are public adjusters. And I had clients call and tell me this, that two guys would show up in a $150,000 car, start flying a drone around the property. Then they'd walk in the clubhouse and say, I can get your roofs replaced for the cost of your deductible. With little more than that, some people signed up for it and some didn't. And, I don't know if it's just the same two guys or if there were multiples that were doing this, but I know one client was given that offer and they turned it down. Their neighbor took the deal. And when the pair of public adjusters lost the claim, the association still owed them 30 grand because their fees were hidden in the proposal. And even though they'd lost the claim and it should have been filed in the first place, they still got their money. So those kinds of claims there's a lot of things going wrong in the market right now, but those kinds of claims are absolutely at the center of where our issues are in the market and why we're seeing such substantive increases. And the last note I'll throw out there is, so they say in Florida, insurance companies get sued more often because, well, they turn down claims more often. Well, a lot of these companies are also writing between Texas and Alabama and Louisiana, and they're not having the same issues. There are a couple of legal factors that make it conducive for the attorneys and public adjusters to specifically chase these claims in Florida, where they're not incentivized the same way in other states. So you may make an argument that maybe in Florida, they've turned down some claims that they shouldn't have, considering you have the same companies working for at least 4 or 5 other states that have seen major hurricanes. I don't know if that accounts for a 68% disparity in total claims versus litigated claims. So
yeah, no, Matt, you make a great point. And, I have my personal feelings about some of these issues, but keeping it objective, I think that public adjusters do serve a valuable service to owners immediately after a major, storm, where we have a hurricane and somebody's had substantial damage to their home and the insurance carriers don't have enough manpower to get out and timely adjust claims and get checks to insureds when they've been rendered homeless.
Even some of those adjusters aren't honestly that great. Like I remember after Irma, I had a 75-year-old woman who didn't speak English show up to a roof claim without a ladder. You can't make that up. So public adjusters are absolutely necessary in certain instances, but typically against it being the lawsuit being the first notice of a claim.
Yeah, I think that but you also hit the nail on the head with the reference to the 75-year-old. I think the reason why Florida may stand separate from those other states is because of the particularly, we have a high concentration of senior citizens, and there's an opportunity to take advantage of people because they just don't know their rights. So, they can serve an important role. On the other hand, they can only take a claim so far, and then they've already, when an association hires a public adjuster and is committed to pay a percentage of the recovery, but then you still got to hire legal counsel, even if it's on a contingency. So much of the claim has been committed that by the time the association is done and they see their net recovery, they're not real happy. So, so again, before you retain a public adjuster to adjust a claim, definitely seek legal counsel's advice and have that contract reviewed. But
all good points.
Yeah, so that concludes our presentation on the 22 legal update. I want to thank everybody for their attending. we greatly appreciate the opportunity to present today. Peggy, thank you so much for having us.
We had
You're
one,
welcome.
Was there another question?
Matt, you want to grab that?
Yeah, we've got one last one that got submitted. Goes on budget approvals. Does the board have to disclose the salary for the property management company's employees?
Well, they wouldn't have to disclose the salaries of the property management's employees because that's something between the property management company and the and their employee, because they're not the association's employee. But certainly what gets paid to the management company is something that would be readily disclosable. So the contract price is what the member is entitled to know. If, on the other hand, the employees are employees of the association, actually on the association payroll, then that is information that the membership would be entitled to. So that's a bizarre distinction, but that's just the way it works. Yeah.
Okay, well, thanks, everybody. Thank you, Steve. Great opportunity to get updated, everybody. And Katie, thank you. I want to thank Matt for moderating again and all the sponsors. And like I said, Layla, we can't do this hardly without you anymore. So thank you so much. Don't eat too much candy and don't get spooky, right?
Thanks, Peggy.
Thanks, Peggy.
See y'all soon.
Bye-bye.
Thanks so
Thank you.
much.
Bye.
All
Bye.
right. Bye-bye.
Good to see everyone.
Bye-bye. Very good.